Good morning. My name is Stephanie Cates and I'm with Merchant Processing Solutions. Today we're bringing you another very interesting interview with Marty Elberg of
Circle of Life Legal Services.
Legal Services. Yeah. I wanted to put life first. And Marty, go ahead and introduce yourself properly.
That was perfect. Marty Elberg, Circle of Life Legal Services, where we do estate planning and probate.
So the reason why I was on a call yesterday with Marty, and he was mentioning businesses that may not have wills, or they may not have family wills that include the business side. And I was like intrigued by that, because especially if you're a sole proprietor of a business or an LLC, one or two partners, or a husband and wife partner, this is something that you want to, I want you to talk about.
Okay, great. So really what I was angling at are just what you said. So people that own a business. So if it's a sole proprietor where they have not incorporated or they haven't created an LLC, and they don't have a will, they don't have a trust, they don't have a plan to transfer that business to their kids or their spouse or whoever they want to have that business. Usually if it's 2, 3, maybe even 4 or more owners, they've got a plan inside of their corporate documents that explain how that business is going to get transferred. But usually I find that people that are owning it by themselves, they might not even have those corporate documents. So they're not even, there's nothing there. So what would happen is they would have this business, and if it's an asset worth passing on, then it would have to go through probate. And the probate would then determine who gets that business. So if we've got the kids working in the business and it's a married man, let's just say, and they're married to the kids' parents, the business is going to go to the wife, not to the kids that are working in the business. So it's really important to make sure the business is included in a full estate plan.
So during that time of probate, can you keep your doors open?
You can keep your doors open, and there are other ways to make sure your company runs by naming officers, which is something we would talk about in our estate planning conversation. So you appoint officers so the officers can continue to run the business. So just as long as you're not the only officer, you're probably okay. If you are the only officer, you're the only one that can sign checks, then we've got an issue. So we've got to really rush to the courthouse to have somebody appointed as the personal representative that can then appoint a new officer for that company. Otherwise, you're kind of stuck in the water unless you'll get a bank to agree to work with you because of any other relationship that you have with them.
So again, I'm just trying to grasp my hands around it. So besides the first document, you said like a trustee or appointing who will get the business, okay,
right.
Or a survivorship or whatever.
Right. And again, this is if somebody does not do any planning at all. We can plan around all of this to make it seamless.
I understand that, and that's where we're going to get to. But I got customers that I know that are sole proprietors.
Right.
And I've asked them, what happens, are you set up with the provision of hit by the bus? You get hit by a bus tomorrow, what happens to your business? You built up a business of, $50,000, $60,000, and you probably like it to continue on, grow, maybe, and you don't have a partner, but you have a wife, but she's not, really doing it. So my question was, can someone leave the survivorship, and I'm sure it's not the right word, to the wife or kids, but in the meantime, someone who knows the business, maybe an employee or someone, come in there and like sign the paychecks or do something? Or would you suggest not, just give it to whoever the survivor was? Or if they don't have a survivor, how do you delegate someone to sign those checks? And can you do it prior to that bus hitting you?
Okay. All right. So yeah, there are a lot of things that this business owner can do. All right. So The first thing I said, already mentioned, was having an officer in place that's already there to take over in case something happens to the owner, the president. Okay, the owner is usually going to be the president. So they can name somebody as the secretary treasurer so they can step in. And as long as the corporate documents say that the secretary treasurer has the authority to make those decisions and sign the paychecks and continue to get business, then you're good there. Getting into the estate planning side, if you have a power of attorney, somebody can step into that business owner's shoes and continue to run that business as if he or she were that business owner. Now, whether that power of attorney is the spouse or a highly trusted individual that knows the business, that's going to determine who that business owner is going to name. And they can name two different people. They can name one person to take care of the business entity. They can name another person to take care of personal finances.
So I have had two instances. A woman who lives down the block, estranged from her husband. He owns his own business. I believe it was a sole proprietorship, but it did well. Mm-hmm. He, unfortunately, with his kids visiting, had a heart attack and died in the kitchen floor. She has now found out he does not have a will, doesn't have a trust. Mm-hmm. And now she's fighting. This has been going on for 6 months or more. She's fighting with the employees to figure out, somebody is writing checks over there. She's not getting any more, which is she was supposed to. It's just become a convoluted mess. She can't close down the business because she's not named in anything. She's an estranged wife. So it can be very hairy. And right now she's living with her father with 3 kids.
Yeah.
This is what she's been because she can't pay the mortgage, the rent on the other house. Secondly, I had a gentleman who was a sole proprietor. He was a painter. He subcontracted his people. And again, he came home one night, went to sleep, and never woke up. And the problem was that he had outstanding jobs. He had jobs that were ready to be paid. And his kids can't seem to get a hold of anything or anybody. I guess all up here or maybe a few on the computer. Tell me, how do people get themselves into this messes, and what do we need to do to get out of it? If you're
that's actually a trick question. They don't do anything to get themselves into the mess. They fail to plan to keep themselves out of the mess.
Yep, I got you. So
both of those situations. Well, actually, the first situation could have been taken care of very easily. The second situation is more of a systems issue with the painter.
Yeah.
That he had records and systems in place, then he could have, people could have stepped in and figured out.
And this is just the last time I heard from one of the sons that, the father, it's a mess and they don't know what to do with the house and he owns it. Again, this is all preventable.
It's all preventable. It's all, I wouldn't say preventable, but a lot of the unknowns can be taken care of through proper planning.
Unfortunately.
Again, the painter, preventable only if he would have had proper documentation on, I've got this job coming up, I've got this job that's supposed to be paying me. If he had all those records, that's done. But that's not part of estate planning, that's part of business planning and business systems. So that makes it a little tougher to deal with. But if he had somebody that was appointed as a personal as a power of attorney while he was still alive, and he got hit by the bus and didn't die, then we can have somebody step in his shoes. Okay, let's go back to the wife, the estranged wife, still married. She still has all of her marital interest in any of his assets, including the business. So really what she needs to do is go to probate, open a probate case, be appointed as the personal representative for his estate. And then she has some authority to talk to these people that are still running the business. So that's that extra step. Now, had in the estranged world of marriage, right? That's not what the husband probably wanted. The husband probably wanted it to go to somebody else. So the husband, business owner, should have made a plan where the wife gets her marital share, or followed through it and got a divorce. That's the best part of estate planning if you don't want your estranged spouse to have it. But back to all seriousness, he could have set up a trust. He could have set up at least a will, transferring ownership to who he wanted it to go to. But right now, the wife has, just based on your scenario, she's got an interest in the business and needs to go to probate to access that business.
So you're telling me that even though okay, so you've gone the extra mile, you've registered with the IRS, you've done your articles of incorporation, you've done everything, and you are a corporation or an LLC. You really don't have to include all of that stuff, correct, into your will or trust?
No. It's not incorporating the documents in there. It's making a plan. A succession plan is really what it is.
Okay.
And that can either be through a will, it can be through the corporate documents, it can be through a trust.
Okay.
I usually recommend a trust. That keeps us out of probate court. Anybody that owns real estate should have a trust, and that asset, that real estate, should go into the trust. That way we don't have to go through probate to have it go from the deceased person through probate to whoever it's going to go to. The trust keeps it out because think of it as an entity. It's not an entity, but it keeps it out of probate, and it just flows right through.
So your documents will go ahead and say protect your desire. And then if it's put into just a normal family will or trust, it can do about the same thing. Talk to me about the family trust and the family will and how those documents would become part of that plan that you talk about.
All right. So let's go back to a sole proprietor, just somebody that owns a business, or a husband and wife that own a business together. Mm-hmm. They can create a trust, either an individual trust or a joint trust if they both own the company together. And in that business, they can in the business part of it, they can transfer the shares of the business to the trust. Okay. Now the trust owns the business, and the husband and wife, we'll just call them, they own it. They would be in control of the business as officers of the business, as well as co-trustees of the trust. Trustees are the people that manage the assets inside of the trust. Okay, they still benefit from the business because they're the beneficiaries of the trust as well. They're also the grantors to the trust because they're the ones that gave the property to the business, or to the trust. So they haven't lost any interest in the business. They haven't lost any control in the business. They haven't lost any benefit to the business. They can change it anytime. They can revoke it anytime. This is one of the most widely used types of trust. It's a revocable living trust, or you might hear of it as just a revocable trust or a living trust. Interchangeable names, but they all do about the same thing. And that trust then continues to survive when the person dies, or when let's say both of them become incapacitated, or one dies, one's incapacitated. They can name a successor trustee to step in and manage all of their assets. And so because the company is one of the assets in the trust, that trustee can manage that business, and that business can go on just like it had been.
Wow. Okay. All right. So that's very interesting. Now, getting into the actual trust, you mentioned on the call that one of the things that people have to do right now, especially with the COVID-19, the coronavirus, is make sure that kids over 18, as well as individual adults, have what they call not a living will. Would you?
Yeah, that's part of it. So
Okay.
a lot of people refer to the whole document as healthcare directives. All right, so it's important that everybody has a healthcare directive, and a healthcare directive will include, or you can do separate documents. Here in Florida, I use a combined living will, healthcare surrogate with the HIPAA authorization. All right, I'll explain the three parts to that. So the living will portion is the life support. A lot of people think of it as the pull the plug document. So if you do not want to be left on life support, you are directing the medical facility as well as the people in your life that I do not want to be left on life support. You're not leaving that decision to anybody. You are designating absolutely do not want to be left on life support if I've got a terminal condition, end-stage condition, or if I'm in a vegetative state. Now, the medical facility is going to make that determination that, hey, there's really no medical certainty that they're ever going to come out of this, reasonable medical certainty that they're going to come out of this state. And life support's the only thing keeping them alive. So they've already made this decision, so we're going to go ahead and pull the plug. Okay?
Yeah.
There's a little bit more to it than that in reality.
Unfortunately, we went through that.
Yeah.
We went through that recently, and
yeah.
It wasn't like a week before they made a determination. Yeah.
Right, and they're not going to make it lightly. They're not going to say, "Oh yeah, no." It's not going to be a light decision ever, and it's more for peace of mind for the family, because the family is saying, all right, he doesn't want to be left on life support, so let's honor his wishes. Where we get into trouble is when there's not a living will and you've got either a spouse or a couple kids that are fighting because, oh no, mom wants to be left on life support. No, mom doesn't want to be left on life support. Yes, she does. No, she doesn't. Yes, she does. That causes huge issues. But if mom would have said, do not put me on life support, or do not keep me on life support, I do not want to be there, let me go, now that argument is lessened at least. So that there's evidence that mom is at peace with where she is. So that's the living will portion of it, okay? The naming a healthcare surrogate, so a designation of a healthcare surrogate is the second part, and that's naming somebody to make medical decisions for you if you're not able to. So if you're in a coma, if you're in that vegetative state, if you are just in surgery and they need some guidance on what to do, the hospital can call this person can answer questions. The hospital will then have authority to talk to that person because we've included the HIPAA authorization, which allows the medical facilities to turn over medical information to even have that discussion.
So much stuff.
There is. And it's a pretty simple, straightforward document, but it's really, really important, and everybody should have one. So you mentioned kids that are 18. They're not kids anymore. They're adults now. They get to make their own decisions. And parents are not automatically given the healthcare information from their doctors. They're not supposed to be. I know in some facilities they still do that, but they really shouldn't. And every 18-year-old and above should have a medical medical directive, a healthcare directive that we're talking about. Everybody that's single absolutely should, because yes, we all have the default person. So it's going to be, if you're single, it'll be your kids if they're adults. If they're not adults, it'll be their parents. And they might be living with somebody, which we see a lot nowadays. So that person that they're living with doesn't really have any authority to help with any medical decisions, even if they've been living together for 20 years. There's no legal tie unless they've got a healthcare directive. So that's really where those two categories, the 18-year-olds and the single people, come in.
So years ago, close to 10 years ago, I was living in Colorado, and my dad asked me to be the executor of their estate, and he passed away, and that left mom getting into a assisted living facility. And from there, she got sick a few times, ended up going to a memory unit. But the first time she got sick, or the second, it wasn't just easy. It was, we need to get approval because she had already been showing signs of dementia.
Mm-hmm.
And they didn't want me to do it like over the phone. They didn't want me to fax anything. So I literally had to get the attorney to give my sister, who lived locally, at first it was just a one-time a medical power of attorney.
Right.
And the more the family talked about it, it was just ridiculous. I'm living 1,500 miles away. She's in Vero Beach, Florida. It's just ridiculous. So again, you might want to give somebody you like, but it's realistically who can show up at the hospital,
Right,
and actually
right.
talk to the doctors, to sign something, to do something. Isn't that the better option?
That's a really good point. I always recommend at least one alternative. So we've got somebody that you want to make the decisions ultimately, but if that person's not available or unwilling, then we move on to the next person. And you should always have somebody local for the medical.
Okay, that's really good. Well, Marty, this has been great information, and especially in light of what's going on today. Again, we go back to the hit by the bus. Your kid's riding a bike, he gets hit by the bus, he goes to, and you mentioned this yesterday, he goes to a hospital and you don't know what hospital he went to. Did he go to Cleveland? Did he go to Memorial? Did he go to, whatever? And
Mm-hmm.
you can't find out because you call them up and he was 21 and he still lives at home, but you can't find anything. So by having that, now let me ask you a question. Is it by hospital that these medical directives or medical health care, how do I know? I mean, what if I say my son has a medical, do I have to send it to all these hospitals so they'll tell me, oh, he's here, he's here, he's here?
Most likely, unless, all right, so just recently, actually, I finally got my medical records online. My doctor sent them to me and sent the, there's a link and I have to put all my medical records in there and all my medical documents are in there. So I can upload whatever I have into there. So that's the universal system. And if it's in there, they should be able to pull it up if they've got his name and information and they can pull up the records. If not, you call the hospital. They say, I can't tell you. Well, tell me your fax number. I'll fax you my healthcare directive, and then you'll be able to talk to me. They say, yeah, sure.
Yeah, I've known people to go to hospital after hospital looking for family members because they couldn't get any information over the phone. And sometimes it's too late when that happens, unfortunately. Yeah. So this has been really good. So Marty, if someone needs a healthcare directive, if someone needs a living will, a trust, how can they reach you? And did I hear you have some free consulting for some people?
Yeah, absolutely. Can I share my screen? And
Absolutely.
Okay, let's see if we can get this. All right, so this is a healthcare. This is just a healthcare directive. I'm just going to scroll through it so you can see what's in here. It's an explanation of why you need one, who needs one, what it is, and then quick instructions on how to fill out the document. And here's the actual document. And I'll pop back up to this page here. This has all of my contact information. So it's Circle of Life Legal Services. There's the address, phone number, 754-800-9747. Or you can email me at marty@circleoflifelegal.com. Ask me any questions you want. I will send you this free healthcare directive brochure with the form. And any other type of estate planning you need, I'd be more than happy to help you with that.
Wonderful. Last thing, Marty, send me one of your business cards so I'll put it in the thumbprint, which will have your lovely portrait, as well as your name and your phone number and email. This will make it very easy to go back and see that instead of scrolling through the entire rest of the video. So, Marty, thank you so much for being on the call today. This is going to be valuable information for many of our viewers.
Great. Thanks for having me. It was fun.
You too. Take care now.
All right. Bye.
Bye.